to kasan abin da ya faru shi sai mu canza location. Loyin gwamnati sun kawo sama matasa da mu kowa faɗi ya kai
You know, 3 cases were filed by the state against members of the IMN, you know, pursuant or, you know, coming from the incident that occurred in Zaria in 2015. Now, in this very last case that was decided today, 91 defendants were being tried. Of course, as you're already aware, in the other cases, we had 41 defendants in one of the cases and then about 49 defendants in the other case, all of which, you know, were dismissed, all of which the charges against them were dismissed, and of course they were set free by the Honorable Justice Young a little over a year ago. In this one, these defendants also have been in custody, you know, since 2015, when the incident in Zaria occurred. Sometime about 5 or 6 months ago, the state closed their case, having called 31 witnesses, you know, and tendered over 100 exhibits, you know, before the court. After they concluded their case, we x-rayed the evidence carefully and were satisfied again that the state had failed, and very woefully so, to establish a prima facie case against the defendants. Of course, you are already aware that the defendants were standing trial for offenses ranging from culpable homicide punishable with death, where they were suggested to have killed one Corporal Kaduna, and of course, other offenses including conspiracy, criminal conspiracy, disturbance of peace, and restraint, unlawful restraint, you know, among others. At the end of the prosecution's case, like I said, we x-rayed the evidence and were satisfied that the state had failed to prove any of the offenses, even though at a prima facie level. That is to say, based on all the evidence that had been put forward by the state, even if the evidence was to be believed as it stood, there was no case that was properly made out against the defendants that warrant them to enter a defense in the matter. So based on that conviction, we filed a no-case submission and we laid out all of the offenses for which the defendants were standing trial. We laid out all the evidence that was supplied by the 31 witnesses that the state called to the stand. Having done all that, we looked at the law in terms of the ingredients that need to be put forward by the prosecution, you know, to warrant a finding at the end of the day that a prima facie case has been made out against the defendants. And we were able to show that in all of the independent charges that were brought against the defendants, the prosecution had failed to prove its case. It may interest you to note that just like in the other 2 cases that were thrown out earlier that I mentioned, the state, for example, brought the defendants, 91 of them, to court and suggested that they had killed one Corporal Kaduna. Under cross-examination, when I cross-examined one of the witnesses that they brought, particularly the chief investigating police officer, he actually stated in evidence that the army had suggested that they were the ones that mistakenly killed Kaduna. It is in evidence before the court. The army actually stated to him that they were the ones that mistakenly killed Kaduna. But here they were presenting persons before the court and charging them for an offense which they knew, obviously, these persons did not commit. Having made an okay submission, of course, the state had an opportunity to respond, and then we waited, of course, for the court to go through the evidence, look at the laws and the arguments we had supplied, and then come to a determination in terms of the case, which was what happened today. I am pleased, that at the end of it all, the court was able to see into the rules that was presented, by the state, and find, just like we had insisted, that the state had failed to put forward a prima facie case against any of the defendants.
Now, we have read the ruling. My Lord discharged them after a no-case submission. She discharged and acquitted them and said that we didn't present any legally admissible evidence before the court. Now, we have looked at the judgment. I have listened to the judgment because I was in court when the judgment was delivered. The judgment is erroneous on point of law because 31 witnesses were called by the prosecution, including senior military officers that were at the scene of the incident when it happened, and they came to testify and gave a vivid account of what happened on that day, what happened to them on that day. Over 105 or 6 exhibits were tendered and legally admitted by the court. And for the court to somersault and say that we have not made out a case warrant us to test this ruling on appeal. And accordingly, I've been directed to file a notice and grounds of appeal as soon as we obtain the record, the full record of the court before the Court of Appeal. That is the position we are in now. Judgment, we are not happy with the part my Lord said that we have not presented any legally admissible evidence before the court. That is the part that hurt us the most. This trial lasted from 2016 to date. Like I said, senior military officers, senior police officers, senior pathologists testified before the court. Senior ballistician from Lagos testified. And the court said we've not presented the legally admissible evidence. We must test that. We must very well test that in the Court of Appeal. It's only the Court of Appeal that will say otherwise. But here now, we are preparing, we are trying to obtain the record, and then we will appeal against this judgment, definitely.